Frequently I'm asked to determine whether a will is valid and whether a will contest is something that would be beneficial to a beneficiary or a family or a spouse. Courts start off with the premise that a testator has the ability to make his will, that he's of sound mind and disposition and makes a will, and they're going to follow that will, and it's presumed that that will is valid until you prove otherwise. There are a number of ways to approach and attack a will. Undue influence is probably the one used and most successful. It has to be more than simple relationships with the deceased that are not real honest and right. It has to be far more material than that. The burden is to establish that the testator, the deceased, really had no free will to make a decision to begin with. And that's a pretty strong burden. Duress is another way of setting aside a will. Duress involves either physical or emotional abuse, usually physical and power, to force someone to do something they don't want to do. And most often, the relevance of that attack is related to the ability of the person to resist and the physical frailty and health of the person. Whether the testator has capacity, a disposing mind, whether he knows the bounty that he's leaving and to whom it's leaving, is related to testamentary intent, whether he had the actual intent and knew what he was doing. Courts are pretty strong on this. You're going to have to show that that loved one who passed away didn't know what he was doing when he made or signed this will. And it's not a test of whether it was fair, just, true, or equitable. It's all irrelevant. It's whether he knew what he was doing. I frequently ask my clients, did your daddy ask him the day before he did his will, who's he going to vote for in the next election? He said, yeah, I know I'm going to vote for, and he gave you a name. You got a problem. Testamentary intent is often related to illness, frailty, and weakness. The onset of Alzheimer's, especially in the mid and latter periods of Alzheimer's, dementia, insanity, or delusional people who may be sane but delusional at the time they signed the will. Courts have upheld some folks that are quite unstable without proof that their instability was manifest at the time they signed the will. Fraud and deception are an obvious attack of the will. If the deceased testator didn't know what he was signing, or if he was in a coma in a hospital and one of the heirs prepares a will and picks up his hand and signs his name, those are perfectly good grounds to set aside a will. Once you set the will aside, the court has a lot of options. They can generally set the will aside and the property passes by intestate succession. You just go to the rules of the law and it passes under Texas law. So the heirs going down first and then straight up to the, if there's nobody down, there's descendants that goes to descendants, and there's some complication in that analysis, but it will not go as set out in the will. A lot of times if the attack is at one provision of the will, the court can't set aside a provision and maintain the will with regard to the rest of the devise and descent set out in the will. At the end of the day, did the testator know the consequence of his actions? Did he know what he was doing? If you're going to have a will prepared for a family member, or if you want your will prepared, and you have some mental or physical ailment that could cause trouble for your whole family, if you have a less than discerning member of your family that you know will cause trouble, videotape it. Have, instead of the 2 witnesses required under Texas law, have 4 witnesses on your will. Have one of them be a nurse. And have the tape of your execution of the will include a number of questions. Who are you going to vote for this year? Who's your favorite child? Questions that show you know what you're doing, not that you're brilliant and not that you don't have memory losses. You can even have Alzheimer's in the early stages. But the concept of setting aside a will is at the instant in time it is signed, not before and not after. So if you can establish on a video and make a record of your compos mentis status at that time, it's very, very doubtful any judge will entertain an attack. And your property will pass as you choose and wish for it to pass. Additionally, it doesn't have to be fair. If you're compos mentis and you've shown it and proved it, and you want to leave every dollar of your $20 million to the cat hospital, that's probably a poor example. How about the Cancer Fund of the Heart Association? There's not a thing your heirs can do about it. Take great care in the preparation of your will and who your executor is. That executor has the power and the means to distribute your estate according to your wishes. Be sure you have many successors. You don't want the court appointing somebody that is less than motivated than a family member or someone with financial sense in your family would have to fulfill your wishes after you're gone. The use of testamentary trust, that is a trust in your will, or inter vivos trust, a living trust you make before you die, are very instrumental and helpful to passing your estate without probate. Avoid the lawyers altogether. Avoid the court altogether. There may be some issues that require legal counsel in a trust situation, but having to file, admit it to probate, get letters testamentary, do an inventory and appraisal and a list of claims, those issues can in large measure be avoided by simply setting up a trust and leaving in the trust exactly as you would in your will.
NACAW Law Firm, may I help you?